All right, so for the recording, you missed my first joke, but everybody else here got it. So what we're going to talk about today is Medicaid. Medicaid is the government program that will pay for some care in your apartment, in your home. It'll pay for assisted living, and it'll pay for nursing home care. And all of that type of care is very, very expensive. So right now, for instance, the Jewish home at Rockley, which is one of the preeminent nursing homes in Bergen County, is charging $16,000 to $17,000 a month. Okay, Christian Healthcare Center in Wyckoff is charging $16,000 a month. I find it interesting, by the way, that the Jews and the Christians charge the most money out of all the nursing homes. Right? All the others in between charge around $12,000 to $14,000. So it's really expensive. And even if you pay for home care, if you need someone to come in and maybe help you with making food, or help you with your laundry, help you with your hygiene, that sort of thing, that could be as much as $10,000 a month, depending upon how many hours that those folks would be coming in and helping you. So Medicaid is the government program that pays for that. The problem is it's not easy to get into the program because it is set up for poor people. Okay, so unlike Medicare, right? I'm assuming that everybody looks to be too young in this room for Medicare. But when you reach a certain age, when you reach 65, you automatically receive your Medicare benefits. Now, Medicare does not pay for nursing home care. It does not pay for home care. It may pay for a little bit of rehab if you go from the hospital to the nursing home, but that's only going to be for a certain amount of days, and then after that, you're on your own unless you can get into Medicaid. Okay, so how do we get into Medicaid? Medicaid is based upon your assets. If you're single, your assets must be reduced to $2,000 or less. That's how poor you have to be to get into the program. If you're married, your spouse, the spouse who's healthy, the spouse that doesn't need the care, that spouse is entitled to retain the marital home, if there is a marital home, and then a car, a vehicle, and then they take everything else that the married couple owns, and the healthy spouse can keep half of that, but not to be more than $130,000. And the actual number, it's a little more than 130, is in the handout.
Is that cash or does that include your home?
No, so it's your home, it's your car, and then half of everything else, not to be more than $130,000. So what is the everything else? Okay, it is your bank accounts, it's your stocks, your bonds, your mutual funds. It's your life insurance if the life insurance has value while you're alive. Two types of life insurance. You have whole life it builds up value while you're alive, and term has no value until you die. You can keep your term, but whole life they'll consider just as if it's cash. Okay? Your IRAs all got to be down to these numbers. So your IRA is not protected. Interestingly, if you're in New York, or you go to a New York nursing home, your IRAs are protected, but not here in New Jersey. So let's call it the pot. Everything goes into the pot. If you're not sure, it's in the pot. Your savings bonds, it all goes in, half, not to be more than 130. So it's the amount, if you're single, it's the amount over 2,000. If you're married, it's the amount over 130. That my job is to find a way to protect it. Because Medicaid says you got to get down to these numbers, and there's only two ways to do it. I've been doing this for over 40 years, and there's only two ways to get rid of your money. One way is to spend it on yourself, and the other is to give it away. If you can think of another way, let me know. You can't put it under your pillow and hide it. That's a crime. What's that? Give it to a nonprofit. There you go. Okay, well, that's giving it away, right? So Medicaid says it's okay to spend it on yourself, and they don't care how you spend it. So you could pay your rent, you can go on a vacation. Let's say you've got $50,000 and you want to get it down to $2,000. You can go around the world in 80 days and spend all your money on yourself and come back and get Medicaid. And the government would be okay with that because you spent it on yourself. You did not give it away. All right. So you could go around the world in 80 days with your boyfriend, but you'd have to spend it on you. The boyfriend would have to get his own plane fare and his own motel room and all that kind of stuff. It'd still be worth it, right? Yeah, okay. All right, so you want to find ways, therefore, you're either going to spend this money or you're going to give it away. We'll talk about giving it away in a minute, okay? But let's look at ways to spend it that might make sense. If you're married and if you do own a house and one of you is sick and the other's allowed to keep the house, then you can spend your money on the house. Make the house the best house on the block. You can put a new roof on the house. You can put a swimming pool in the backyard. You can get new appliances, a new kitchen, a new stove, a new bed, flat screen TV, all the things that you never wanted to spend your money on because you were thrifty. It's better to spend the money on those things than to pay the nursing home. So you can spend down your money any way that you want. If you had debt, you can pay off all your debt. So if you're the spouse who's living at home and your husband or wife is in the nursing home, Medicaid's paying, and you're allowed to keep a home, a car, and only $130,000, you want to make sure that the car is brand new because you're not going to have the money to fix it. Well, you can go out and buy a new car. You want your hot water heater to be brand new because you're not going to have the money to fix it. You're only going to have $130,000 and you want to be able to live on that. So you're going to be able to buy all these new things if you've got extra money rather than to spend all that money on the nursing home and then apply for Medicaid. If you have any debt at all, credit card debt, home equity loan, a mortgage on your house, debt on the car, you can pay all that debt off. That's part of your spend down in order to apply for Medicaid. So let's say you had $300,000 in the bank and you have a house and we know you can keep 130, so that leaves you with 170 that we would have to spend, and you've got a mortgage for $200,000 on the house. We could pay down the mortgage. Now you haven't really spent anything. You reduced your debt and you have the 130, you haven't wasted any money at all. Okay? So we want to look at those ways to spend money wisely so that in effect you kind of get it back at the end of the day. What I like to tell, I teach a class at Bergen Community College on this stuff, and what I like to tell the students is, you know, what your Medicaid says you're allowed to spend your money. So you're allowed to, for instance, buy all new floorboards in your house. What you're not allowed to do is to hide the money under the floorboards, right? So you can't hide your money, all right, but you are allowed to spend it. The other thing you're allowed to do is to give away your money. Give away your money to somebody you trust, of course, so that they can hold it for you. But Medicaid says, well, the problem is if we let everybody do that, if we let you give away your money, everybody would wait to the day that we're wheeling you into the Jewish home, and then you give away your money. Well, and then everybody would get Medicaid, and you know the country would go bankrupt. So Medicaid says if you're going to give away your money, if that's the way you're going to get down to 130 or down to 2, you're going to have to wait 5 years before we're willing to give you the Medicaid. So there's a 5-year look back, that's what they call it, whenever you apply. And what they're doing is they're looking to see have you given anything away during that 5-year period. Okay? And whether you've given away a little or whether you've given away a lot, you're going to be penalized. You're going to be punished for doing that, and the penalty is a financial penalty, so you don't want to do that. You want to if you're going to give away your assets, what you're hoping for is you're going to give it away, and then you're hoping you're going to stay healthy for 5 years. And at the end of 5 years, that money will be, I'm saying money, it could be anything. It could be your house. Those assets will be protected, and then you could apply for Medicaid if you're down below $2,000. So, you know, it's kind of a balancing act when it comes to if you're going to give assets away in order to protect them. While we're healthy, we like to control our money, right? We don't want to give it away. I mean, my daughter, my wife and I have, you know, one child, a daughter. She's a lovely, lovely young lady. She's 32 years old. But I'm starting to get nervous right now thinking about giving my money away to her, you know. I don't know what she's going to do with it, all right? And I like the idea that I can look at my checkbook, you know, every month. I remember my father, he had a little investment account, maybe $50,000 in stocks, And this was when computers first came out, and he had an Apple computer, and he would look at the stocks 3 times a day. He'd call me at the office at noon and say, my stocks went down. And I'd say, Dad, just wait till 3 o'clock. They'll go back up again. So it's nice to be able to do that. So you've got to decide for yourself, based upon your health, when is the time when maybe it is better to give away the assets in order to protect them rather than to hang on to them to the bitter end. And the way I like to describe that is, usually there's kind of a scale here. So, on this side of the medium is Mother Teresa, right? Mother Teresa, at age 25 gave away all her money. She didn't worry about her money. So she'd be very willing to give it away at any time. That's Mother Teresa. Down on this end of the scale are all those old Italian guys that when they're going into the nursing home, they're holding their bank book in their hand. You can't even get it out of their hand. We don't even know what's in that bank book. Most of us are somewhere in between in deciding, when we're going to do this. So let's say that you say, well, you know what? Yeah, I would be willing to give away my money, but how do I do that? What happens when my money is not in my name anymore? Who do I give it to? Do I give it to my children? Do I give it to a trust? How do I give away a house? How do you go about that? So whenever you're considering transferring assets in order to protect those assets, you have to worry about basically 3 things. 1, what happens if the child you give it to dies? What happens to your money now that that child has died? What happens if that child gets a divorce? What happens to your money that's in that child's name when that child gets a divorce? What happens if that child goes bankrupt with your money? Where does your money go? Okay. What do you do if you've got 6 kids in the family, or you've got 1 child in the family? So the first thing is, the easiest way to do this, not necessarily always the best way, it might be, but not always, because there are 2 ways of doing this, is you're going to give your assets to your children. And for argument's sake, let's just say you have 3 children, okay? So you've got your daughter, who's a saint, you've got your son, who's an alcoholic, and you've got your other son, even worse, he's a lawyer. Okay, so those are your 3 kids. 1 out of 3, I guess, isn't bad. And you want to give your assets to somebody that you trust. Well, you don't want to give it to the alcoholic, and you probably don't want to give it to the lawyer, but you're willing to give it to your daughter. But on the other hand, when you die, you would like to divide your assets between the 3 kids, even though one of them's a lawyer. You want to treat them equally. So what you can do in that case is you give the assets to your daughter, the child you trust, and you have the 3 children sign a contract. They sign an agreement. And the agreement says, we, the children of Bob and Trish Romano, acknowledge that our parents have given us the following assets. And we actually have a schedule on the back of the agreement, and we list the assets, whatever they are. And we, the children of Bob and Trish, agree that we're only going to use these assets for our parents' benefit while our parents are alive. We're not going to use it for any other reason. Okay. Now, if one of the children tries to take the money and go to the south of France on vacation, the other 2 could sue the 3rd child. He signed an agreement. He's got to abide by the agreement. The agreement can say somebody's got to manage this money, while you're alive. Well, it could say the assets will be managed by unanimous consent, or it could say the assets will be managed by my daughter while I'm alive. So all this can be incorporated into the agreement, so we know who's going to be holding the money, who's going to be managing it, and you have in black and white that the children will give the money back if you need it, especially during that first 5 years. Okay, so let's say you do that. Now let's go back to those 3 questions. What happens if one of the 3 children dies and the assets are in that child's name? Well, the child signed an agreement, and the agreement says as long as mom and dad are alive, the assets are used for mom and dad. So the agreement, in a sense, is like a cancer. It attaches to the money. So if the child dies and the child's got a will that says, I leave everything to my husband, oh my God, the son-in-law, he can't touch the money. Not until mom and dad die, because the child signed the agreement while she was alive. Okay? So if the child dies, the assets are still protected for the parents. The other children now will manage those assets. Right? Well, what happens if the child gets a divorce? The law in New Jersey is if there is a divorce Assets that are given by parents to children as a gift are not subject to the divorce. They're not subject to equitable distribution as long as the child, the spouse, doesn't commingle the assets. You don't put your husband's name on the account. And the agreement is going to say that the assets are held by the children, not by the in-laws. So if somebody dies, we don't have to worry about it. If somebody gets a divorce, we don't have to worry about it because of this agreement. Very simple. But what happens if a child goes bankrupt? I can't protect you against the child's creditors. So if you were worried about that, now a lot of clients will just say, look, my kids, they're not in a high-risk business. They've got good insurance. I don't anticipate they're going to go bankrupt, and so I'm okay. Let's just do the agreement, okay? But if your child is in a high-risk business, maybe he's a doctor, maybe he's a lawyer, and you're worried, hey, you know, if they get sued, they could lose everything. Maybe he's a developer, and developers go bankrupt all the time. God forbid he's Donald Trump. You don't know, you know, Donald may be going bankrupt again. All right. So if you're in a high-risk business, you can't afford to do this with the agreement. So instead, what we do, it's an alternative to the agreement. Instead of giving your assets to your children, we're going to create a trust. And a trust is just, it's a fancy word for words on a piece of paper that tell us what to do with whatever we're putting into it. So the trust is a separate entity. It's separate from you, and it's separate from your children. It's something that's created by the lawyer, okay? And you can now create an account in the name of the trust, but you have to have a trustee, which is going to be one of your children. And the trust is going to be created for all of your children. So now you have your assets in this trust. 5 years after they go into the trust, they're protected. And your children can go bankrupt. It doesn't make any difference because it's the trust that's holding the assets. But the trust is a little more complicated. In the agreement, you can read for yourself that your children have signed something that said, we're going to hold these assets for mom and dad. Trust doesn't say that. The trust says, we're holding the assets for the children. It can't name mom and dad. Because when you apply for Medicaid, one of the questions on the application is, are there any trusts for mom or dad? And if there are, Medicaid includes those assets as if they're still yours. So if we're going to create a trust, it can't be for you. It has to be for your children. Well, then how do you get money back if you need it? The only way to get it is you've got to trust your children that the trustee will write a check to one of the other children, and that child will write a check back to you. Okay? So the trust is a lot more complicated. It's a lot more sophisticated. Just 1 second. And one other thing is, whoever's holding your assets, assume that those assets start to earn interest, earn dividends. Somebody's got to pay the income tax on that. So if your children are holding it, it's very easy. They pay the income tax. They're not going to be hurt because the income tax can't be more than the income. So if you earn $1,000 in income and the tax is $300, we just take it out of the $1,000. They're not going to be hurt. It just shows on their income tax return, nothing special. But when you have a trust, the trust has to have its own income tax return because it's a separate entity. So now every year you got to pay the accountant to do a separate income tax return. So again, the trusts are more complicated. If we can avoid them, we try to avoid them, but sometimes they're necessary. If you've got a very complicated estate, you're giving a lot of assets, and there are different types of assets. Again, if you're worried about bankruptcy, we may need to do the trust. You had a question.
Yeah, is this agreement that we're talking about, is that the power of attorney?
No.
Oh.
No. This is all only when you're giving away assets to protect them. I'll talk about the power of attorney in a minute. Yes.
I have a question about your first scenario where you give the money to your kids.
Right.
And one child dies.
Right.
Can you specify if it's in a trust? Can you specify that if the child dies, the money goes to the next children
Yes.
alive? If
Yes.
you don't want it to go to the child's
Yes.
spouse?
That's right. Absolutely. You not only would you should.
You should.
Yeah. So what you're saying is whether you're using the agreement or you're using a trust, when the child dies, you don't want the money to go to the spouse. You want the money to go to your grandchildren, right? And so yes, you would put that in there. But none of that would happen until you die, okay? So if your son died the year after you did the agreement or the trust and you're still alive, we're not giving any money to the grandkids at that point. It's staying there for you. And then when you're gone, yes, the grandkids would receive it, okay? So whenever somebody comes in and they're trying to protect assets and they're going to need Medicaid, we're kind of doing a combination of, spending down and making these gifts. And if we know, for instance, you've got a $200,000 mortgage on your house, we know that if one of you needs Medicaid, the other is going to be able to pay off that mortgage. Well, we don't need to give anything away because we'll be able to get you Medicaid very quickly just by paying off the mortgage. But if you have, a lot of my clients, 1945, the World War II was over. By 1946, they paid off all their debt and they never incurred any more debt. They just keep putting their pennies in the bank account, and now they got $1 million, okay? And they don't have any debt. Well, they're either going to spend that $1 million on the nursing home, or they're going to need to give it away because it just isn't going to be that much that they can spend. All right. Yep.
Do you have a set amount where you sort of, if somebody has $4 million, do you say to them, you're probably not going to need Medicaid?
That's right. That's right. So what's your first name, if you don't mind?
Victoria.
Was it?
Victoria.
Victoria. So what Victoria is saying is this, and I just had this case yesterday. Somebody comes into my office. I want to know, do they have enough money to pay for 5 years? Okay, which is a lot. I mean, that could be $600,000. But let's say that you've got $600,000 in your IRA. You know you can't give away an IRA. If you do, you got to pay all the income tax. So you got $600,000 in your IRA, and you're single, okay? And you've got a house, and maybe you have a house down the shore. I mean, you're pretty lucky, and then you got another $1 million, okay? And the kids are saying, Mom, you ought to give us the $1 million, and you ought to give us the houses because you can lose all these if you go into the nursing home. And anyway, you got $600 in your IRA. Well, why would you give away those assets now? Because even if you did, and even if 5 years goes by, you still can't get Medicaid because you got $600,000 in your IRA. So instead, we can wait until we're rolling you into the Jewish home, wait to the very last minute, and then if we have to do it, you're no worse off. We can give the houses, give the $1 million, and we've got the $600,000 to pay for the 5 years. So there are cases where, if you're wealthy enough, you don't need to do any of this, at least not until you absolutely have to. Okay, so we're talking about folks that don't have, that type of money. A big question that I get is, how do I protect my house? Okay, a lot of us, that may be your biggest asset. It may be your only asset, and you don't want to lose it. You don't want to I've got to go into a nursing home. I don't want to lose my house. All right. So, and so you're prepared to give it away, and you're prepared to wait the 5 years, okay? But what happens if you do give it away? So let's just say that, today the lawyer does a deed and transfers your house to one or more of your children. They own it, you do not. Well, the first thing is you just lost your homestead rebate credit because you don't own the house anymore, and they're not going to get it because they have their own house. So the family lost the homestead rebate credit. If you're a senior citizen and you're making under a certain limit, your real estate taxes are frozen. Well, you just lost that if you gave the house to your kids because they're not senior citizens, okay? If you're married to a veteran or you're a veteran, you're getting a discount on your real estate taxes. You just lost that by giving the house to the kids. And now someday, those children are going to sell that house. Maybe after you die, maybe before you die. Whenever they sell it, they've got to pay capital gains tax on the profit from what you bought it for back in 1952, okay, and what they're selling it for. They got to pay tax on the entire profit. They're not going to be very happy about that, okay? But you could do that, and 5 years after you do it, the house will be protected. But there's another way to do it where you transfer the house to the children, but in the deed, the lawyer writes some magic words that basically say you get to live in that house for the rest of your life, if you want to. You get to use that house for the rest of your life, if you want to. It's called a life estate. All right, those are the fancy words, but the idea here is written into the deed, kids are the owners, I'm allowed to live there. They can't kick me out. And let's say you decided to move and you wanted to rent the property. You get the rent because you have a right to use the property while you're alive. Well, why would we do that? Number one, because you kept the right to live there, you keep the homestead rebate credit, you keep the senior freeze, you keep the veterans discount on real estate taxes. So all those little perks you were getting, you're still getting. And from the children's perspective, as long as they do not sell the house until after you die, they don't pay capital gains tax. All of the profit from the date that you bought the house to the date of death is no longer subject to tax. So they get a big, big tax benefit by waiting until you die to sell the property, and by putting those words in the deed. You get all your perks, and plus you get to see in black and white, nobody's kicking me out of my house, unless you want to go. Okay. So when we're transferring real estate, and that, by the way, that could be a transfer to the children, that could be a transfer to the trust. We can still use the life estate in no matter how we're going to do it. All right. On the other hand, let's say you came to me and you said, I'm going to be moving in here. I'm going to be moving into Brookdale, so I'm going to sell my house. Okay. Well, if you're going to sell your house, then I don't want to give it to the children, because when they sell it, they're going to pay the capital gains tax. But when you sell it, you get a tax break because it's your primary residence. So if I know in advance you're going to be selling it relatively soon, you can sell it and then give the money to your children and let the 5 years go by. So you can give the money to your children, let the 5 years go by. You can give the house outright and lose all those perks, or you can give it to the children with the life estate. That would be a way to give away your house. Now, I've said, I think more than once, that you do have to wait 5 years if you give away assets, whether you give away a little or whether you give away a lot. Just be careful about this. There is a gift tax law that some people know that says you can give away a certain amount, right, to as many different people as you want each and every year. And you don't have to tell the government. You don't have to file a gift tax return. You're not going to get Medicaid unless 5 years goes by. That's a different rule, okay? So that rule, that right now, by the way, it's 16,000 is the rule. It used to be 10, all right? So you can give away 16,000 to as many different people as you want. You don't have to file a gift tax return, but you're not going to get Medicaid, or you'll be penalized if you don't wait the 5 years. So, because it's a different law. And by the way, how do you give away a house if you're only allowed to give away $16,000 per person per year? That's a pretty small house, right? All right. The reason why you can is that 16 per person per year rule just says you don't have to file a return. But you can give more than that, and you still don't pay gift tax. You just have to tell the government. You have to file a return. You're allowed to give away up to $12 million over your lifetime without paying gift tax. So just judging the way, none of you are dressed any better than me, and I don't have $12 million to give away, so I don't think any of you may. Alex may have $12 million, I'm not sure. But so my point is, you can give away a house, and the house on Long Beach Island, or wherever, because it's not going to be more than $12 million. All right, but just remember that even though you're giving a little, maybe you're giving $5,000 or $10,000, you'll be penalized if you don't wait the 5 years. Now, are there any exceptions to the rule? Of course, there's always exceptions to the rule. So one exception to the rule is if a child is living with the parent in the parent's house, okay, so your son or daughter is living in your house with you, okay, and is not working, and for 2 years has been taking care of you around the clock, you can give your house to that child and you don't have to wait 5 years, okay? It's called the primary caregiver exception. Now, there was a time when all we had to do to meet that exception was to get your doctor to write a letter and say, yeah, without Bobby living in the house, my patient would have needed to go into a nursing home 2 years ago. That's not good enough anymore. If your son is living in your house but he or she is working, then they can't take advantage of the rule. So they want to know that that child is devoting 24/7 to the parent. And under Medicaid's rules, if you're working, well, obviously you're not dedicating yourself 24/7 to the parent. So you have to have a child that maybe gave up their job or wasn't working in the first place, and then he's got to show, what he's been doing for the parent. But if you can meet those requirements, we can give away the house. We don't have to wait 5 years. Another exception to the rule is if two siblings are living in a house together and own the house together. Now, there's a word that I'm told is politically incorrect. I'm not allowed to say it, so I'm going to whisper it. It's called spinster. Okay, I didn't know that was a bad word. Okay, but that's a way to remember that, spinster, or again, the sister who didn't marry. I think that's what it means. So you have, say two sisters that never married, two brothers that never married, a brother and a sister that didn't marry, whatever. Your siblings are living in this house together and they own it together. You can give your house to your sibling and you don't have to wait the 2 years. Does anybody remember the Waltons? The Waltons, right? You know the show, The Waltons, okay? It's my favorite show. I found it on a station way, way up on the cable numbers. I can still watch it. Well, on the Waltons, okay, they had two, and they called them spinster sisters. Do you remember the sisters, okay? They're what's that?
The Baldwin sisters.
The Baldwin sisters, that's right. That's right, there you go, okay? Victoria knows. So the Baldwin sisters never married, and they were the richest ladies on Walton Mountain because their father was a judge. And the father used to make moonshine, right, which we weren't allowed to do back then, okay? And the sisters, I kind of think that they had Alzheimer's. They didn't know what Alzheimer's was back then because they used to make the recipe, right, Victoria? And they would give the recipe out to everybody. Everybody on Walton Mountain would come to the sisters to buy the recipe, but they didn't know that the recipe was moonshine. And by the way, the sisters indulged quite a bit with the recipe. So when you think about the Waltons and you think about the Baldwin sisters handing out the recipe, if one of them needed to go into a nursing home, I don't think they had nursing homes back on Walton Mountain, but if they did, they could have given the house to the other sister, and that would have been permissible. They wouldn't have to wait the 5 years. All right, that doesn't happen all that often. But a big exception to the rule, this is the third exception. This one I see quite a bit. If the parent has a disabled child, the parent can give anything to the disabled child, not just the house. Can give the house, can give money, stocks, bonds, mutual funds, you name it, and the parent can give it away and doesn't have to wait 5 years. Now, the problem sometimes is this. The disabled child might be on Medicaid. And if you're on Medicaid, you can't have any money. You got to be below $2,000. So how does the parent give money to the child and the child keep Medicaid? So there's a thing called a special needs trust, and we create them for people who are disabled. The parent can give the assets to the disabled child special needs trust. The child keeps Medicaid. The parent gets Medicaid. Everybody's happy, and you don't have to wait the 5 years. Okay. Now there are some disabled people that are not on Medicaid. So if I become disabled and I've worked all my life, I get SSD, Social Security Disability. I'm allowed to have money. So if my mother wanted Medicaid and if I was disabled and on Social Security Disability, she could give me the money directly. I wouldn't need a special needs trust. But if I'm getting welfare and I'm on Medicaid myself, then the mother would have to give it to the special needs trust. So say you've got 3 children and one is getting Social Security Disability. You could give all your assets to the child who's getting Social Security Disability, and then he can share it with the other children. Everybody's happy. And you don't have to wait the 5 years. And if you don't have to wait the 5 years, then you don't have to give the assets to the disabled child unless it's absolutely necessary. You can again wait to the very last minute before doing that. So you can wait till, if you really know that you're going to be going to the nursing home. You don't want to pay the nursing home everything you have. You give it to your disabled daughter, and then your daughter divides it up with the other 3. And sometimes we have them sign an agreement to make sure that they're going to do that. Okay. So you probably have heard there's a lot of urban myths out there about nursing homes, in order to get into a good nursing home, you've got to give them a lot of money. In order to get in a good nursing home, they're going to take all your money. They want it in a lump sum. There's all sorts of ideas out there. So this is the way it works. When Medicaid pays the nursing home, Medicaid pays at a reduced rate than what we pay as private citizens. So if the Jewish home is charging $17,000 a month, Medicaid may only give them $10,000 a month, and they'll take it. They'll take Medicaid. You don't have to pay once you're on Medicaid. Okay, so but because of that, most nursing homes do not want to take Medicaid from the very first day that you enter. They want you to pay at the higher rate for at least a period of time. Now they're not looking for money up front. They're not saying you got to give us $100,000 up front. They just want to be paid each month for a certain amount of months, and then they'll take Medicaid if you can get it. Okay, so most nursing homes, if you can pay at the private rate for 6 months, then they will take Medicaid. These are nursing homes. Okay, now the Jewish home at Rockley, the Christian Healthcare Center, again the Jews and the Christians, they will try to get a year's private pay from you at that higher rate. So if you want to absolutely be sure you can get into any nursing home in the state of New Jersey whenever you want to reserve a year's private pay, because that'll get you in anywhere at any time, no questions asked, and you can get Medicaid after that. Okay, but if you're not a prima donna and you say, well, I don't got to get in every nursing home, okay, but if you can guarantee me that I have choice of maybe 5 or 6 different places, all decent places, well, then you only need to reserve 6 months private pay. Okay. Now, if you're legitimately poor, you haven't given any money away, you just never had it to begin with, and you don't have anything, and you can't pay anything privately, well, now your choices have gone way down. And if I'm representing you, I'm going to spend the day on the phone calling one nursing home after the other until I can find one that's going to do me a favor and is going to accept you in with little or no private pay. And again, one of the advantages of either an elderly attorney or an elder law attorney is that as we get to know the different nursing homes, it could be that last week I put a millionaire into that facility. This week they better damn well do me a favor, because if they don't, they're not getting another millionaire. I'll go somewhere else. So, the lawyers can help you get into a quality place, even if you don't have, all of that private pay. I want to come back. I forgot something. Remember I said before, if you're married, you get to keep your house. And you get to keep a small amount of money. And I said, if you need to spend money, spend it on the house. So you might say, well, what good is it going to do me fixing my house up so it's the best house on the block when I can't afford to pay the real estate taxes? Once my husband's in the nursing home, I don't have his income anymore. How am I going to pay the real estate taxes on the house that I just put 30, 40, 50,000 in by fixing the roof and the garage and everything else? Once the spouse who's ill, once that spouse gets Medicaid, you get to do whatever you want with what you are allowed to keep. So if you're allowed to keep a house, a car, and $130,000, once he's in the nursing home on Medicaid, you can sell that house, and all the money goes to you, and he still has Medicaid, right? So now you could sell that house. Say it was worth $500,000 in Bergen County, and you put another 100 in because you're trying to get rid of your money. All right, and you put a pool in the backyard, all right? Even though you're 98 and the last time you went swimming was, when you were 75, okay? But you put a pool back in there, and I don't know, you did all these different things. Now the property's worth $600,000, and once your husband's on Medicaid, this is the fun part, okay? You sell your house, right? You got $600,000 in your pocket, and you say to your boyfriend, "Come on, it's time to go down to Florida," and you buy a little condo in Florida, and you have all that money in your pocket, okay? So when I say, we're going to be spending money on the house, it's because you're going to be able to keep that house, all right? And you could sell it, and it won't interfere with his Medicaid. You're going to get to keep all the money from the sale, all right? Now, somebody asked me about a power of attorney. This really wasn't a program about powers of attorney, but we have more time, right?
Yeah, definitely.
Okay, so we're going to talk about that. So one of the things as an elder law attorney that I do, obviously, is we get calls all the time. Hey, how do I, the first call is, when should I start thinking about protecting my assets, right? I mean, I have people, 62 years old. I want to protect my assets. What do you mean you want to protect? You're going to give away your assets at 62? 62 is the new 42, okay? So I usually tell my clients the time to at least think about it is mid to late 70s, okay? Before that, I'm 71, before I'm gonna give my stuff away. Before that, I don't think you even need to think about it, okay? But when you're into your mid 70s, late 70s, that's a time to at least understand what you could do at some later date. And then you can decide when you want to do it. Okay. But what everyone in this room, including Alex at her young age, okay, what everyone in this room should have are legal documents that we're going to talk about right now. Okay. And there are 4 of them. Okay. So the first is a durable power of attorney. That's a financial document, a durable power of attorney. And that's a document where you're going to name somebody who's going to handle your money for you if you can't handle it yourself. So if you suddenly get sick and you can't pay your bills anymore, and you can't invest manage your investments, and you can't give away your money, you can't do this planning because you're too sick, you've named someone to do it for you. And of course, you always want to name an alternate. It's durable because it's a document that the moment you sign it, if you give it to the person, they can use it. And it continues until you die or until you revoke it. So if you get sick, it's still a valid document. It endures beyond your sickness. That's why it's durable. All right? So you sign it today. The person that you're designating, if you give it to that person, they can use it tomorrow. And they don't have to prove you're sick. They don't have to prove that you're in the nursing home or you're in the hospital. They just have to prove I'm the person named in that document. So it's a very powerful document. But they can't use it unless you give it to them.
Oh, so don't tell them.
So you don't give it to them. Well, of course you tell them.
People in other states, every state has its own.
Yeah, but we're in New Jersey, and we're talking about New Jersey.
You don't have to tell people that you've named them as your power.
Now, look, of course you're going to tell them, but you're not going to give them, what good is it if you don't tell them? You're now in a coma in the hospital, and they don't even know you did the document, and they're tearing your house apart. What the hell did my mother do? Did she do it? Didn't she do it? Who do I call? What do I do? Of course you're going to tell them, but you're going to say, Mama's no fool. She's not giving you this document, but this is where it is. If Mama gets sick, come look for it, okay? Don't put it in your safe deposit box because they can't get into the safe deposit box. The document may say they can get into the safe deposit box, but without it, they can't, okay? So you want to put it somewhere where they can come get it if they need to, okay? That's assuming you don't trust your children. I mean, if you trust your child, then you might want to give it to them in advance, and that would be fine. My mother, who's gone now, but I mean, in the 70s, I didn't even know where her bank account was. She wouldn't even tell me. In her 80s, I knew where the bank account was, but she wouldn't give me the power of attorney. At 89, I got the power of attorney. She died at 90. So you decide when to give it. But there are powers, I'll be with you in a minute. There are powers of attorney where you could say, this document only goes into effect when I'm sick. Okay, that's called a springing power. You don't want that. Don't write it down. Don't use it. It doesn't work. And this is why. Whenever you use a power of attorney, there's always 3 people involved. One is the person someday who's going to need the help. That's the person who's signing the power of attorney. That's you. Okay. The second is the person who's going to give you the help. It might be your husband. It might be one of your children. And you're always going to have an alternate in case the first person can't do it. But the third person is the person who your son or daughter or husband is bringing the document to and saying, please, mister, I need to use this document. That's the bank teller. That's the life insurance company, right? That's Medicaid. That's the accountant, the lawyer, the real estate broker. And other than the lawyer, all those other people that I just mentioned, the bank manager, the insurance salesman, the stockbroker, they all wanted to be lawyers. They weren't smart enough. That's why they're doing the other things that they're doing, okay? And you're now giving them the opportunity to play at being a lawyer. Because when you walk in with the document, this document is only good if your mother's sick. Huh, I think I want to take her deposition. Bring her in the wheelchair. I would like to talk to your mother. I don't know whether she's really sick or not. I want to know for sure. I think I want 3 letters from 3 different doctors telling me that your mother's sick. And they better tell me just how sick she is, because I'm not going to use this document because it's a springing power, and I don't have to use it unless you prove to me that that can do. You don't want to go through all that. The purpose of the document is we're going to need it, and when we need it, we don't want to have a problem with the person we're bringing it to. Think about this. When you go to your stockbroker, when you go to anybody, and you're asking them to do something for you, they're either going to say yes or they're going to say no. It's so much easier for them to say no, because then they can say, "Go away. I don't want to be drawn into your nightmare." So we want them to say yes when we bring this power. A springing power gives them the opportunity to say no. So we never use it, okay? So durable power of attorney, yes, it's a very powerful document. You're only going to choose somebody that you trust. You're not going to give it to that person unless it's absolutely necessary. Okay, put that aside. Second document, medical power of attorney. By law in New Jersey, a medical power of attorney only goes into effect, no matter what you say, when your doctor makes a determination that you're not understanding what he or she is saying. I'm not talking about you're at the end of your life. I'm just saying, maybe you're on some wonderful drug that you're high and you just don't understand. You're in la la land, okay? And he needs to make a decision and you can't help him. All right, who did you name on your medical power of attorney? The doctor will go to that person. So that's a very important document. And again, you want an alternate if the first person can't do it. That's a document that you should give to the person immediately. Give it to your doctor, give it to that person, because it can't be used unless your doctor determines it's appropriate. You don't have to be afraid to give that away. Now, you did have a question, and I asked you to hang on.
So it's really good power of attorney. When my mom died, before she died, we had to get signatures for the banks. The banks demanded that we become backups on her account.
Right.
They wouldn't just accept the power of attorney.
Right. So
my question is that still true?
It wasn't true then, and it's not true now.
Cut it out.
And again,
They just did
listen.
that?
You just proved my point. When you went into the bank and you asked them to do something, it was easier for them to say no than it was to say yes. See, the financial institutions are only interested in themselves. Forget the commercials on TV. They're only interested in themselves. They don't want to be responsible if you, the child, go into that account and steal the money, and then they get sued. They don't want that. So yes, they make it difficult. And even if you have a power of attorney, they'll say no until your lawyer calls up and says, "Wait a minute. Of course you're going to accept that power of attorney, because the law of New Jersey requires you to accept that power." And then you know what they'll say? "Oh, I never said I wouldn't accept it. I never told her that. She must have misunderstood what I said." All right?
We had to go into when my mother was.
I believe you, and I'm saying the bank did that, but if your lawyer had called them, he would have cut through everything. So the law is that they must accept the power of attorney. Right. So everybody hear that. If the power of attorney is done properly, they must accept it in the state of New Jersey. Okay, so we got the financial, durable power of attorney, the medical power of attorney. The third document is the living will. It's also a medical document. Now, a lot of lawyers, a lot of people put the medical power of attorney and the living will into one combined document, which there's nothing wrong in that. I do 2 separate documents, not because I charge by the page, but because they do 2 separate things. I explained the medical power of attorney. It could be something as simple as, should I take an aspirin or a Tylenol, and you're not understanding, and the doctor's got to talk to your daughter about that, right? You go into the hospital for a heart attack. The doctor either is going to send you home with a bottle of Lipitor, do angioplasty or open heart surgery, and maybe you can't communicate. He's got to talk to your daughter, okay? But what happens if you're at the end of your life? What happens if there's nothing else the doctors can do to make you better, and if you cannot communicate in any way? Because if you can communicate and you're at the end of your life, the doctor is going to say, "What do you want to do?" And you'll tell them, okay? But if you can't communicate, and I mean you cannot squeeze a finger once for yes, twice for no. You cannot blink your eyes once for yes, twice for no, okay? And